Most retirees spend decades building their wealth, but far too many leave their estate planning until it is too late. Without a proper plan, your family could face unnecessary taxes, legal battles, and months or even years of court proceedings. Today, we are going to cover the essential estate planning documents and strategies that every retiree needs to know. Welcome to the Retirement Classroom. If you are new here, we publish deep dive retirement education videos every week. Hit that subscribe button so you do not miss a single one. Before we get into the details, a quick note. This content is for educational purposes only and should not be considered individual financial or legal guidance. Everyone's situation is different. Please consult with qualified professionals before making decisions. If you are looking to speak with a retirement professional about your unique situation, scan the QR code on screen or check the link in the description. Let us start with the federal estate tax because the rules have changed significantly. Under the Tax Cuts and Jobs Act of 2017, the federal estate tax exemption was roughly doubled. In 2025, it stood at approximately $13.61 million per individual, or $27.22 million for a married couple. However, this higher exemption was scheduled to sunset at the end of 2025. Depending on what Congress has done, the 2026 exemption may have dropped back to approximately $7 million per person, adjusted for inflation. This is a critical number because it determines how much you can pass to heirs free of the 40% federal estate tax. If you have a significant estate, you need to verify the current exemption amount with your tax professional because this directly impacts your planning. Beyond the estate tax, there is the gift tax annual exclusion. In 2025, you could give up to $19,000 per recipient per year without any gift tax implications. For a married couple, that is $38,000 per recipient. This is one of the simplest and most effective estate reduction strategies available. If you have 3 children and 6 grandchildren, a married couple could gift up to $342,000 per year completely tax-free. Now let us talk about the 5 essential estate planning documents every retiree needs. Document number 1 is a will. This is the foundation of any estate plan. Your will specifies who gets what, names an executor to manage the process, and can designate guardians for any dependents. Without a will, your state's intestacy laws determine who inherits your assets, and those laws may not match your wishes at all. The critical limitation of a will is that it must go through probate, the court-supervised process of validating and executing your wishes. Document number 2 is a revocable living trust. This is often the most important upgrade from a basic will. A revocable living trust allows your assets to transfer to beneficiaries without going through probate. You maintain full control during your lifetime. You can change it, revoke it, or spend the assets. But upon your death, the trust becomes irrevocable and distributes assets according to your instructions, typically within weeks rather than the 9 to 18 months that probate often takes. The catch is that you must actually fund the trust by retitling your assets in the trust's name. A trust that is not funded is just an expensive piece of paper. Document number 3 is a durable power of attorney for finances. This authorizes someone you trust to manage your financial affairs if you become incapacitated. Without this document, your family would need to go to court to establish a conservatorship, which is expensive, time-consuming, and public. Your power of attorney should be durable, meaning it remains in effect even if you lose mental capacity. Document number 4 is an advanced healthcare directive, which typically includes a living will and a healthcare power of attorney. The living will states your wishes for medical treatment if you cannot communicate. The healthcare power of attorney designates someone to make medical decisions on your behalf. You should also sign a HIPAA authorization so your designated person can access your medical information. Document number 5 is your beneficiary designations. This is the one most people get wrong. Beneficiary designations on retirement accounts, life insurance policies, and annuities override your will. If your will says everything goes to your children but your IRA beneficiary form still lists your ex-spouse, the ex-spouse gets the IRA. You should review all beneficiary designations at least annually and after any major life event. Let us talk about probate and why avoiding it matters. Probate is the court-supervised process of distributing a deceased person's assets. The average probate process takes 9 to 18 months and costs 3 to 7% of the estate's value. For a $1 million estate, that could mean $30,000 to $70,000 in legal fees, court costs, and executor fees. Probate is also a public process, meaning anyone can look up what you owned and who inherited it. Assets in a revocable living trust, jointly owned property, and accounts with beneficiary designations all bypass probate entirely. Now, here is a critical area that many retirees overlook. The Secure Act fundamentally changed how inherited retirement accounts work. Before the Secure Act, Non-spouse beneficiaries could stretch required minimum distributions from an inherited IRA over their entire lifetime. This was called the Stretch IRA, and it was a powerful tax planning tool. The Secure Act eliminated the Stretch IRA for most beneficiaries. Now, most non-spouse beneficiaries must withdraw the entire inherited IRA balance within 10 years of the account owner's death. This can create a massive tax bomb for your heirs, especially if they are in their peak earning years. There are 5 categories of eligible designated beneficiaries who are exempt from the 10-year rule. Surviving spouses can roll the inherited IRA into their own IRA or treat it as their own. Disabled individuals qualify for lifetime distributions. Chronically ill individuals also qualify. Beneficiaries who are not more than 10 years younger than the deceased can use lifetime distributions. And minor children of the deceased can stretch distributions until they turn 21, after which the 10-year clock starts. The planning implication is significant. If your children will inherit large traditional IRA balances, they may face tax bills of hundreds of thousands of dollars within 10 years. Strategies to address this include Roth conversions during your lifetime, which shifts the tax burden from your heirs to you at potentially lower rates. Charitable remainder trusts can provide income to heirs while satisfying the 10-year rule. And life insurance can be used to offset the expected tax burden on inherited IRAs. Speaking of life insurance and estate planning, an irrevocable life insurance trust, or ILIT, is a powerful tool for larger estates. When you own a life insurance policy directly, the death benefit is included in your taxable estate. For a $500,000 policy with the estate tax rate at 40%, that could mean $200,000 in estate taxes on the insurance proceeds alone. An ILIT owns the policy instead of you. Since you do not own it, the death benefit is excluded from your estate. The annual premiums are funded through gifts to the trust, typically using your annual gift tax exclusion. There is a 3-year look-back rule. If you transfer an existing policy to an ILIT and die within 3 years, the proceeds are still included in your estate. That is why many people have the ILIT purchase a new policy directly. For charitably inclined retirees, a charitable remainder trust can be a remarkable planning tool. You transfer appreciated assets into the trust and receive an income stream for life or for a term of up to 20 years. The charity receives whatever remains after the income period. You get an immediate income tax deduction for the present value of the charitable remainder. You avoid capital gains tax on the transfer of appreciated assets, and the assets are removed from your taxable estate. For example, transferring $500,000 of appreciated stock to a charitable remainder, Unit Rust paying 5% annually, would generate $25,000 per year in income and provide a substantial charitable deduction. Do not forget about state estate and inheritance taxes. Over a dozen states and the District of Columbia impose their own estate or inheritance taxes, often with much lower exemptions than the federal level. Massachusetts and Oregon have exemptions as low as $1 million. Washington State has a top rate of 20%. And states like Pennsylvania, New Jersey, and Iowa impose inheritance taxes based on the relationship between the deceased and the heir, with rates varying from 0 for spouses to up to 15 or 16% for non-relatives. If you live in or own property in a state with estate taxes, your state-level planning is just as important as federal planning. Here are the most common estate planning mistakes retirees make. Mistake number 1 is outdated beneficiary designations. Review them every year. Mistake number 2 is not funding your trust. The trust only works for assets titled in its name. Mistake number 3 is no durable power of attorney. Without it, incapacity triggers expensive conservatorship proceedings. Mistake number 4 is failing to plan for the 10-year inherited IRA rule under the Secure Act. Mistake number 5 is ignoring state estate taxes, especially if you live in a state with low exemptions. Mistake number 6 is joint ownership as a substitute for proper planning. Adding a child to your home's deed, for example, can trigger gift tax issues, expose the property to the child's creditors, and eliminate the step-up in basis at death. Speaking of the step-up in basis, this is one of the most valuable tax benefits in estate planning. When you die, your heirs receive your assets with a cost basis stepped up to the fair market value at the date of your death. If you bought stock for $50,000 and it is worth $500,000 when you die, your heirs inherit it with a $500,000 basis. If they sell immediately, they owe 0 capital gains tax. This is why, for appreciated assets outside of retirement accounts, holding until death can be more tax efficient than selling or gifting during your lifetime. Here are the key takeaways. The 5 essential documents are a will, revocable living trust, durable power of attorney, healthcare directive, and updated beneficiary designations. The federal estate tax exemption for 2026 may have changed due to the TCJA sunset. Verify with your tax professional. Probate costs 3 to 7% and takes 9 to 18 months. A funded revocable trust avoids probate entirely. The Secure Act 10-year rule creates potential tax bombs for heirs inheriting large IRAs. Consider Roth conversions, CRTs, or life insurance to mitigate. ILITs remove life insurance proceeds from your taxable estate. The step-up in basis eliminates capital gains tax for heirs on inherited appreciated assets. Over 12 states impose their own estate or inheritance taxes with exemptions as low as $1 million. If this breakdown helped you understand estate planning basics, hit that subscribe button and turn on notifications so you do not miss our next deep dive. We publish new retirement education every week.
Hey, before you go, if you're serious about your retirement, we'd love to help. Scan the QR code on screen right now or visit the link in the description to book a completely free strategy session with a qualified professional. It only takes a couple minutes to fill out, and there's absolutely no obligation. Take the first step today. We'll see you in the next one.